Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. And friends, welcome back. We are in Murray, Calloway County with attorney Jeff Roberts. Jeff, how are you today?
I'm doing good, Jim. How are you?
I'm doing well, man. Hey, I thought for this episode, let's go ahead and jump into Social Security disability. And there's a couple of programs that we want to kind of talk about. You have a substantial practice built on Social Security disability. You also do workers' compensation, and you do general personal injuries, such as car wrecks, truck wrecks, motorcycle accidents,
Correct.
things like that. And oftentimes, we'll probably touch on this in this episode, sometimes those all three relate into one case. So it's really kind of interesting how that works. But let's talk in general terms about Social Security disability.
Sure. Social Security disability, the Social Security Administration administers two different disability programs: Social Security Disability Insurance, or SSDI, and then Supplemental Security Income, or SSI. And the disability determination is the same for both programs. If you're disabled for one program, you're disabled for the other program. It's defined the same for both programs. It's the non-disability requirements that are different between the two programs. SSI is paid out based on financial need. So you have to meet a limit on your resources to be able to receive SSI benefits. So if you own a home here in Calloway County and then own a vacation home in Florida, you're not going to qualify for SSI because you have way too much in assets to qualify for SSI purposes. Now, for SSI, one thing about it is that you've never have had to work to receive SSI benefits because it is a financial need program.
It's unrelated completely to any kind of work history, basically.
Correct. Yes, work history doesn't apply. I mean, if you had a work history, the judge may look at that to some extent, but no work history doesn't cost you from being able to receive that program. Now, they will look at how much money you have in the bank, how much money is coming into the household that you're in, expenses going out, things of that nature as well. So there's a variety of factors they look at on the resource side of it, or asset and resource side.
And I thought that was interesting. You said specifically how much income's coming into the household, because it's not necessarily how much this person earns versus the spouse. It's a household basis, isn't it?
Correct. They will look at the household to see what is coming into that entire household. So if the spouse is earning a very good wage, but then the claimant is not capable of working, has never worked, so they can't draw off their own earnings record, which we'll talk about in just a second, the spouse's income would knock them out of eligibility for SSI, or could potentially reduce how much they receive. If it doesn't completely knock them out of eligibility, it could reduce how much they receive in SSI.
And with SSI, because again, it's not based on work history, a child could also get SSI benefits, right? This
Correct.
is not work-related.
Well, a child can receive it. It's a little different determination for a child from that standpoint, but they can, disabled children can receive that benefit. And the reason for disabled children being able to get that benefit is it provides for Medicaid coverage as well. If you're on SSI, you're on Medicaid. And so it provides health insurance for disabled children where parents potentially could not afford it or provide to pay for the medical treatment that the child may need from that situation. So there's benefit for children qualifying for that. The other program is Social Security Disability Insurance, or SSDI, or sometimes just Social Security Disability, referred to it that way. And that is paid out based on what you've paid into the system. So you have had to work and paid into the Social Security system with your taxes that are taken out, the FICA taxes that are taken out, to be eligible to receive Social Security disability benefits. Now, with Social Security disability benefits, they're not looking at household income. They're not looking at how much money you have in the bank. That does not enter the picture on Social Security disability. It is, have you worked enough and paid enough into Social Security, and are you disabled? If you meet both of those two criteria, you receive Social Security disability benefits. Now, with Social Security disability, you have to meet what's called the insured status requirements, which is, again, paying into the system enough to do that, but you had to pay in the right period of time. So if you work for 20 years, stop work for whatever reason, but not for health reasons, because you weren't disabled, but you just needed to stop or wanted to take a break, and you stop work for 9, 10 years, and then you become disabled for a health condition, and you want to go back and file for disability, you've most likely lost your insured status requirements, and you're not going to be eligible to receive Social Security disability benefits.
There's a little bit of a continuity issue there you got to be careful with.
Correct, exactly. Normally, after you stop working, you will lose insured status if you've been working full-time and paying in to Social Security. Normally, it's going to be after you stop working, about 5 years after you stop working, you will lose the insured status requirement. So if your disability starts after you lose insured status requirements, you're not going to be eligible for Social Security disability. You may be eligible for SSI, but you don't meet the insured status requirements to receive Social Security disability benefits.
And, we've had a lot of different episodes where we talk about various aspects related to Social Security disability. And the one thing that I always use as just a tool to help me remember the two programs, SSDI, Social Security Disability Insurance. So that's if I've paid, like paying an insurance premium, I get the benefit. Whereas SSI is Supplemental Security Income. That's income-based. That's means tested. And for me, that's an easy way to kind of break them apart. We've said this in previous episodes, but once again, this has nothing to do with your Social Security retirement. That's a whole different program, correct?
Correct. It's a different program, obviously administered by Social Security Administration again, and there's some interplay between those. You have to earn and pay in to receive retirement benefits, but it's a different calculation and all, and how much you have to pay in, et cetera, for that from there. But with the Social Security disability, and you're correct, it's it's like an insurance, and that's the way the insured. When I talk to people about the insured status requirements, that's one of the examples I use. Is if you purchase car insurance on January 1st, 2025, you pay a year's premium. Well, by December 31st, 2025, you have to pay a premium again for you to have insurance coverage into 2026. It's the same way with Social Security disability insurance. You have to pay into the Social Security Administration, even though they don't call it an insurance premium. It kind of acts the same. You pay into that, and when you stop paying in, eventually you're going to lose that coverage.
That makes sense. Let me go back to a couple of previous episodes just to kind of touch base on it. We talked in episode 76 about a listings of impairment. And that list that's put together is kind of a move to the front of the line type process, because a Social Security disability claim does not move really quickly. Is that a fair assessment?
It's a fair assessment. The way the process works for both cases, they go through the same process, even though the standards are somewhat, the standard non-disability requirements are different. They do go through the same process. You make the initial application. That initial application will be decided by the Department of Disability Services, DDS, in the state that you're located in. That determination, when they render that initial determination, statistically speaking, you're going to be denied. The vast, vast majority of people are denied at the initial level. After you get that denial in, then you file a request for reconsideration. It goes back to the DDS office. They will look at it again, have their doctors look at it again, and then they'll issue a second decision. And again, statistically speaking, that's going to be a denial as well.
And from a legal standpoint, as an attorney, you usually come into play in that second phase, right? A lot of times people can apply by themselves and go ahead and wait for the letter. They may get it, and hey, that's fine, or they may be rejected. At that point, that's when it's probably better suited for you to get involved. Is that roughly?
Yeah, normally my advice to clients or potential clients is to make the initial application yourself. The reason I do that is for that very reason. In my opinion, I don't think there's anything that an attorney is going to do to cause it to be granted, or at least it's going to be a very small amount that an attorney is going to do to cause the case to be granted at the initial level. Those cases are granted because of the very severe nature of the person's medical problems. You've got somebody who's got chronic kidney disease and is on dialysis, or those type of conditions. Those are the ones that get granted initially. And there's no reason, in my opinion, for those individuals to incur an attorney fee. So if you're in that very small percentage that are granted initially, then you don't need to incur attorney fees at that point. So I tell people, make the initial application, because if I do get involved and I've done work on the case, then I've got to charge an attorney fee. The exception to that is people who have significant mental health issues or intellectual issues, and they don't have a good friend or a family member that can help them do the application. Then in those cases, I will get involved at the initial level if the person wants me to. I still try to steer them to having a friend or a family member help them with the initial application, and then come see me when they get that first denial.
That makes sense. And again, that comes down to the statistics of it. Most likely they're going to be denied unless they meet, as we were speaking earlier in episode 76 about that listing of impairment. And you did a really nice job of breaking out all those different conditions, if you will, that might allow somebody to have a better chance of getting that initial approved.
Correct. The listings of impairment, essentially there are a couple of ways to be successful in these type of claims. One of which is to establish that the client meets the listings of impairment. The listings of impairment stated generally are says if you have this condition with these complications, you're automatically considered disabled. Chronic kidney disease and on dialysis. Cancer that can't be treated and expected to result in death within 12 months, things like that. So very, very serious issues. And those type of conditions are the ones, generally are the ones that's going to get granted initially. But if they're not granted initially, and there's several times they do slip through the cracks from there, and the person has to come in and get an attorney to establish that they do meet the listings of impairment. Part of the reason for that is what the listings of impairment, the criteria, you have to have this condition. Most of the time, the medical records document, yes, they've got this condition, but then you have to have these complicating factors or these other things documented as well. And frequently, some of those issues may not be documented in the medical record. Someone with heart condition, then they're going to look at the ejection fracture. Sometimes the medical records talk about what the ejection fraction is. Sometimes they don't talk about what the ejection fraction is. And if they don't talk about it, then we need to get those records to make sure we can document that to show that the client meets the listings of impairment. And that's where the attorney comes in there, because if you get an attorney who knows what they're doing with Social Security disability, they know where to look and say, okay, to meet this listing, we got to document these things, and then reach out to the doctor to get those things documented. From there, that's one way to be found disabled. The other way is to essentially establish that because of your age, education, and the restrictions that you have placed on you, you cannot go back to work a normal job found in the national economy. And in age, education are big factors in that aspect of it. And your past work history is also a factor there. So if you've got a 60-year-old individual who has done heavy manual labor their whole life and who has less than a high school education, well, they're not likely to be able to go to a sedentary job. So if they're limited to sedentary work, they're going to be disabled by Social Security standards. If they're limited to medium work, they're probably not going to be. disabled by Social Security standards, even if they can't go back to doing the heavy construction work. So there's a lot of factors that come into play there, but that's what you're trying to establish. There are some Social Security regulations that basically say if you have this age education and you're limited to in past work experience is this, and you're limited to these certain categories, then you're presumed to be disabled, or you're the medical vocational guidelines of what they called, and either it kind of directs the finding of disabled or not disabled. So you've got to get your evidence to meet what those regulations provide as well to try to be successful for your client.
And I tell you, I love how all of this just kind of interrelates, because in episode 84, we talked about something called the look back period,
Correct.
which has to do specifically with that window of time the judge can look back to
On
see
your
your previous jobs to kind of see, could you go back and find a different type of job? But luckily now that is much, much shorter of a window, or smaller of a window than it used to be.
Correct. Yeah, the look back period used to be 15 years. So they would go back 15 years prior to onset to see what type of jobs you've done. And now they've shortened that to a 5-year time frame because, frankly, the way the workforce is developing, the changes in the workforce, what I did as an attorney 15 years ago from a computer standpoint is vastly different than what I do with a computer now. And it's same with a lot of other jobs. The way the work is carried out and how you carry it out physically and mentally both, and the skills that you need to carry it out change drastically over a 15-year time frame. Over a 5-year time frame, it's not quite as much of a change. So if you had a job 5 years ago, you probably still have the ability to go back and do that job. Now, 15 years ago, you may, if you go back into that job, you're not going to have any better advantage than somebody who's never done that job. And the new regulations take that into account better than they did.
And that also relates, I love doing this, it relates back to episode 67, where we talked about a specific form that is used for the work history. It's the Form 3369. Friends, if you're listening to this episode, I know we're talking about a lot of previous things. In the show notes, which are basically all those paragraphs below where you're listening to the podcast episode today, those are the show notes. And I'll drop links to all of these other referenced episodes in there to make it really easy for you. So, Jeff, let's come back to where we were. We talked about, how the process goes along. The first claim is generally denied. You will step in and help out generally at the point at which they need to file for reconsideration.
Correct.
Let's pick it up from there. Kind of where does it go from there?
And again, as I said before, most cases are denied again on reconsideration. And then you file what's called a request for hearing in front of an administrative law judge. And that's actually the first time a judge your case goes in front of an actual judge. And so that's where most cases are granted. And the time period varies on these. As a rough estimate, normally the initial decision comes in 3 to 4 months after the initial application. The reconsideration process is about the same, 3 to 4 months. I've had cases where, and I think it was because they were giving it a real close look because they thought it was a close call type case, where they've taken 8 months on the initial application before they made a decision. So when I say 3 to 4 months, that's a general guideline. That doesn't mean that's what yours is going to be. It could be shorter. It could be substantially longer. But when you file the request for hearing, the case gets in front of an administrative law judge. And what I'm seeing now probably is somewhere in the neighborhood of about 8 months before we have a hearing in front of an administrative law judge. Again, that fluctuates as well to some extent.
Is that 8 months after the second
Denial.
Okay.
After second denial, after you file the request for hearing, about 8 months after, that's where I'm seeing. Now, it depends because I deal with the hearing office I deal with the most is the Paducah Social Security Hearing Office, but I'm licensed, as I think I've mentioned before, I'm licensed by the Social Security Administration in all 50 states. So I can handle Social Security cases in Tennessee and various other states, and I've handled several cases out of Tennessee, and normally the hearing office I deal with out of Tennessee is Nashville. In Nashville's wait time may be and probably is substantially different than Paducah's wait time. So so it's going to depend on which hearing office you're in on what the wait time is before you get in front of a judge for that hearing. And during that period of time, I'm gathering all the evidence, getting my ducks in a row, so that when we go in front of a judge, we have everything that we need to be successful in that case. Sometimes I'm able to get it all together, and then the judge looks at it. Either I write a letter or the judge looks at it on their own, and they look and say, okay, this is one that can be granted without us having to have a hearing, and that occasionally occurs in cases, and we're successful without us having to go to a hearing. A lot of times, though, we do have to go to the hearing, and then the judge will make a decision sometime after the hearing. If you're not, and the process up until the judge's decision, when you make the initial application, if they deny the case initially and say you're not disabled and you file a request for reconsideration, the request for reconsideration is essentially a new look at the case. The legal term is de novo. They're reviewing it all over again. And so they don't pay any attention to the initial determination, don't give any weight to the initial determination. They're not looking at it and saying, did the initial determination, was it correct legally, not factually, but was it correct legally? What they're doing on the reconsideration is this claimant disabled? They don't care what the first decision was. Is this claimant disabled is what they're looking at. You file a request for hearing in front of a judge, it's the same way. The judge is not looking at should not be given any weight to the decision of the first, at the first level and the second level. They may give weight to what the doctor said that reviewed your records, but not to the ultimate decision. And the judge is looking at it and saying, is this claimant disabled by Social Security standards? After you get a judge's decision, if it is not a favorable decision, if you're not successful, you can appeal that to, first it go to appeals council and then to federal district court. But those are what are really true appeals, because then after the judge makes a decision, then the levels above are looking at it, did the judge commit a legal error? Or does substantial evidence support what the judge did? They're not looking at it, is this claimant disabled? They're looking, did the judge commit an error in deciding this case? So it's a different standard once you go up from the judge's decision there.
And these hearings are unlike what you've seen on TV. I mean, Social Security, disability, SSI claims included. This is administrative law, right? I mean, there's
Correct.
not a jury here. There's not a big courtroom battle like you might see on CSI or some other show. This is administrative.
It is. It's an administrative hearing in front of the judge. The judge will frequently question the claimant. A lot of times, in fact, they will start the questioning of the claimant and go through some general background information, age, education, work experience, things like that with the claimant. And then when it comes to talking about the claimant's medical or psychological problems, they'll let the attorney ask those questions if the person's represented. If they're not represented, obviously, the judge will continue on with those questions as well. So, the judge is more involved than what you're going to see a judge in a jury trial, because in a jury trial, the judge is just weighing evidentiary issues and instructing the jury, but not ever questioning any of the witnesses or anything of that nature. And at these hearings, the Social Security Administration actually does not have an attorney present. Like I said, the judge will ask questions at times, but they are impartial. They're not going to cross-examine you and put you on the spot and things of that nature. But it's a hearing, usually there's a couple of witnesses, the claimant and a vocational expert. Normally there's all of the witnesses that are present. During the hearing, they usually take 45 minutes or so to an hour. Some not even that long, depending on the case. But it's not in front of the public. There's no public there. There's no jury there. It's normally the judge, a hearing assistant who's operating a recorder to make sure everything's being recorded, the claimant's attorney, and vocational expert, either in person or by phone.
It's amazing that when you start looking at the process from, okay, I'm going to file my first claim and then that gets denied, to this point, you're often a year and a half, sometimes 2 years into this process, and you get about an hour, hour and a half in front of the judge for this thing. I mean, it surprises people, I think, but there's a lot of documentation that's been built around what's going on. So there's more than what's happening right there in the hearing.
Correct. It's more than just the testimony of the claimant. All the medical evidence is already submitted. So they've got all the treating doctors' medical records. They should have anyway. If your attorney's doing their job, then they got all the treating doctors' medical records. They've got the opinions of the doctors. If some doctors won't fill out forms offering restrictions, but if your treating doctor will do that, then hopefully we've got the form from the treating doctor identifying the restrictions they would place on you. Occasionally, we may send the person out for an evaluation by a doctor if we have a treating doctor who doesn't do that, or a treating mental health professional who doesn't do those forms, and we'll have somebody do that. So they've got all of those medical records in there. I've had cases where the medical part of the file was well over 1,000 pages of medical records that the judge had in front of them. And most of the claimant's testimony is very, very important in these cases. Don't get me wrong, but the restrictions the doctors impose and how they back up those restrictions are also very, very important. That's part of the file that the doctors don't come testify at the hearing in these cases, because it's all in writing from that standpoint. But even though the hearing itself may only last 45 minutes to an hour, the judge has a lot of information that they're reviewing and go over in making these decisions.
When I started listening to you talk about medical records and vocational experts and other types of experts and gathering all this stuff, and maybe 1,000 pages of medical records in some situations and all this stuff, it sounds expensive. But what's interesting is these are handled on a contingency fee basis. So let's talk about how that works.
Yeah, the way I work on these cases is I do work on a contingency fee basis, which means my fee is contingent upon recovery. If we are successful, I get paid an attorney fee. If we are not successful, then you don't owe me an attorney fee. I also advance all the litigation expenses. That's the cost I incur in representing you in the case. So when I write to the doctor and ask them to fill out this 10-page form of restrictions, that doctor is going to charge me to fill that form out, and they should, because I'm taking up their time that they could use treating patients of theirs. And so, they would get paid for it, so they should get paid for filling out those forms. And so I advance that cost as well. That cost is also contingent upon recovery. If we are successful, then I get paid my attorney fee and reimburse my expenses. If we are not successful, my client's not out of pocket anything to me in that regard. I don't get paid an attorney fee. I don't get reimbursed my expenses. I eat that loss.
And I think that's what a lot of people don't really understand. When an attorney is looking at a case, especially a contingency fee case, they've got to figure out, do I think I can win this case?
Correct.
And that kind of goes into the decision whether or not I can represent this client.
Sure, certainly. If it's a case I know I'm going to lose, obviously I'm not going to get involved in that case on a contingency fee basis. And I will tell the clients. I have a lot of clients come in and they ask me, I have some come in and want to talk before they've ever filed because they want to know if they should file. And one of the first things I tell clients that come in, because I have some come in who are having difficulties, but they're still working. And, there's been a lot of people who sit in this same conference room that you and I are in right now that I've told that you're better off physically, mentally, and financially working if you can work. But if you can't work, then Social Security disability is there as the safety net, the backdrop for you from that perspective. But if you can work, continue working as long as you can. A couple of reasons to that. One, I think that is 100% correct. You're better off physically, mentally, and financially working than you are not working. And as I said before, one of the factors Social Security considers is age. And there are times where my client, by Social Security standards, if they're younger than 55, they would not be disabled. But that exact same fact pattern, the only thing that changes is the person's age. So the medical condition, the restrictions, the past work history is all exactly the same, but the person is now 56, they're disabled. And so by Social Security regulations, so the longer you're able to work, also it can make it a little bit easier to be granted disability, and hopefully your case doesn't take as long to be successful because we have a little bit different standard because you've either turned age 50 or you turned age 55, and those can make a big difference on whether we're successful or not successful in the case.
Fantastic. Jeff, you mentioned a while back that you're licensed, Social Security is a federal program, so you're licensed to practice in all 50 states, when it comes to a Social Security case.
Correct.
Now, you maintain two offices. Today we're in Calloway County. We're in Murray, but you have another office up in Christian County in Hopkinsville, right?
Yes, I do. I've opened that office. I've had it open for a little over a year now, actually. Opened up August of last year, if I recall correctly. And so it's been open for a little over a year at this point in time. And I have Social Security clients up in that area. And I kind of opened that office up, as I've mentioned before, is because I did represent a lot of clients up in that area in workers' comp, car wreck, and Social Security cases. And I set up one day that I'm going to be up there to meet with clients, and it just makes it easier for me to drive up there instead of have 4, 5, 6 different clients come down to Murray for a meeting, for in-person meetings. And I prefer in-person if I can, and that's one of the other reasons is a lot of those appointments we were doing by the phone or by video conference, and I like sitting across a desk from clients and talking face-to-face with people when I can. Sometimes it's not convenient for anybody. I've represented, as we've talked about before, I represent clients all over Kentucky, clients in Louisville, et cetera. And those, it's a little harder to meet face-to-face somewhat. Doesn't affect my ability to represent the person. I still represent the person just fine. But it just personally, face-to-face conversations are, to me, I prefer over phone and video conference. So.
That makes sense. And the way you've set it up, it's interesting. You've actually got one phone number, one normal phone number that they can call and that handles both offices, right?
Correct. Yes, there's one phone number that handles both offices. And to me, it's just easier to do that. And that way, if you call, you're going to get the office. And if I'm not at Murray, if I'm in Hopkinsville, they will let me know, and we can still talk. That's not a problem whatsoever from that standpoint. But if that way, if you call my Hopkinsville, if I had a separate phone line for Hopkinsville that had a different number, you call Hopkinsville office, and then all right, then they said, well, he's at Murray office today. You got to call the Murray office. And I have I have attorneys that I reach out to that have multiple offices that do that, and I call and to speak with the attorney, and as well, he's not at the Lexington office today. He's at the Louisville office. You'll have to call over there, and here's the number. And I don't want my clients to have to do that.
Right.
You call the office, and then you'll get in touch with me that way.
And what's that phone number?
270-753-0053. If you prefer to use 800 number, it's 1-800-844-5108.
Outstanding. And, of course, on the website, jeffrobertslaw.com, there's also a contact form. There's also an opportunity that they can interact in kind of like a chat conversation as well, and those bits of information will get to you as well pretty quickly.
Yes. If you go through those forms, they will email the conversation to me from there, and then I will get back in touch with you quickly from that perspective. And also, you talked about the show notes, but if you got other questions on Social Security disability or car wrecks or workers' compensation, we have pages dedicated to all of that on there that you can go and gather more information. If you have any additional questions about your case, call my office up, and we'll be happy to talk with you about your case.
Outstanding. Jeff, it's been a pleasure, and we'll be back in about 2 weeks.
Thank you, Jim.
Take care, guy. Bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.